Former President Jacob Zuma will now hear tomorrow whether the Pietermaritzburg High Court will postpone his corruption case for him to appear in court physically. The court was meant to hear arguments on his special plea application for the state prosecutor, Dali Mpofu, to recuse himself from the trial, but his legal representatives instead asked for a maximum of a week's postponement, saying they haven't fully consulted with the former president. Zuma's lawyer, advocate Dali Mpofu, argued a virtual hearing would violate Zuma's rights, but the state argues the application is just another delaying tactic. Let's speak now to the legal expert, Benedict Phiri, to unpack these arguments. Benedict, good evening to you. As I understand the way the law works, it is said in the past that a case must take place in the presence of the accused. Has that word presence ever been properly defined? Does it mean physical, or does it mean virtual? Does it mean neither or both?
It has been properly defined, Stephen, and you would have heard Advocate Mpofu referring to sections of the Criminal Procedure Act to say that the only time that it wouldn't take in the presence of the accused is if there were the exceptions of, for instance, ill health, or the conduct of the accused makes it intolerable to have the proceedings in front of him. And, you know, this is a typical sort of global standard, and, you know, lawyers worldwide understand that the accused must be present for trial. And there's a good reason for that, which I think Advocate Masuku argued very well, to say that, you know, being present and participating actually means meaningful participation. It means you can judge the demeanor of the judge, you can see the demeanor of witnesses, you can hear the arguments for yourself and actually have a real-time interaction with your legal representatives, which is something that you cannot achieve very well through virtual proceedings. So I think Zuma's attorneys on this one pretty much on the right side of the law.
So in other words, the state is going to lose this. There'll be a postponement, and we don't really know what will happen from there.
I think it's going to be difficult for the state. The state didn't really deal with the grounds for postponement. Zuma's legal team had put up a number. They had put up, obviously, the issue of him being present physically for trial. They'd put up COVID. They'd put up the threat of violence. They'd also just put up the fact that no physical arrangements were actually made for Zuma to be in court physically, should that have been the case, and the fact that the court was closed. So, you know, Advocate Wim Trengrove didn't really deal with those in substance, really. He started dealing with the merits of the 106 application, and really didn't really deal with the substance of the postponement application. So I'm thinking that Zuma may have a little bit of a nose in front on this one.
So if that's the case, I mean, we've seen, and I think even before COVID-19, because there was always such a risk of bringing awaiting trial prisoners to court, we saw how many had tried to escape. They tried to create a closed-circuit television program into at least one prison, I think, in Gauteng. If the accused in this case wins this, I mean, this is going to have huge implications. Any prisoner would be able to demand the right, even for a 2-minute appearance, to be in court. I mean, if the court rules one way in this case, it should rule in that way in all cases.
Well, awaiting trial prisoners and prisoners that are awaiting remands, or their matters are simply due to a postponement or bail applications, already have the ability of having their matter heard via video link. And the consideration there, which I think the South African Law Reform Commission sort of worked on towards the early 2000s, 2013, roundabout there, is that those aspects or those parts of the procedures of criminal trials do not necessarily go to the fundamental rights to a fair trial, which we're seeing now. And I think if you listen to Dali Mpofu, he said the trial starts the moment the accused pleads. And from there on, it doesn't matter what kind of a skirmish you're involved in, whether, you know, it's a 106 application or whatever. From that moment, the accused has every right to be present physically in every single proceeding going forward. So those kind of, you know, those postponements or remands or bails are provided for in the Criminal Procedure Act and don't quite fit within this framework.
I mean, in a way, one of the problems here is that there's so many postponements and delays in our legal system. That's why there's so many appearances. If we didn't have all of those other problems, this wouldn't be such a big issue. You wouldn't have to keep dragging people to court. Things would speed up a bit.
That's correct, Stephen. That's correct. I think there's much to be said for the well-functioning of the legal system. It certainly frustrates us as legal practitioners, let alone our clients. Certainly something that can be improved. This electronic hearings have been quite a revelation for the Gauteng courts. When they do operate, matters are heard quite expeditiously, and they do facilitate public participation in the matters, as we've all seen.
Benedict Phiri, as always, do appreciate the time. Thank you, legal expert, with the latest on the application brought by former President Jacob Zuma.